Gracious. Welcome to an exclusive fireside chat, courtesy of our partners at Akin, Gump, Hauer and Feld. We have the privilege of having with us Sir Rupert Jackson, who will be interviewed by Mr. Hamish Lal from Akin Gump. The interviewee, Sir Rupert Jackson, was appointed to the English High Court bench in January 1999 and served as the judge in charge of the Technology and Construction Code, the TCC, from 2004 to 2007. Sir Rupert has presided over the heaviest construction and engineering cases coming before the TCC and dealt with many arbitration applications and appeals. He was then elevated to the Court of Appeal in October of 2008, where he delivered some of the leading authorities on construction law. While at the Court of Appeals, he was entrusted with reviewing the civil litigation and procedural rules, famously called the Jackson Report, which brought a number of reforms in the English civil practice. Sir Rupert Jackson is now at 4 New Square, where he sits as an arbitrator. Since then, he has been sitting on numerous international arbitration tribunals. The interviewer, Mr. Hamish Lal, who is a partner at Akin Gump, Strauss Hauer and Feld. Mr. Lal is ranked Band 1 for construction arbitration by the Chambers and Partners UK and is in the top tier of UK Legal 500. He's a true academic and practitioner who was awarded Fulbright Scholarship, the Parkman Medal by the Institution of Civil Engineers, and has authored books on construction agreements and managing and quantifying construction claims. A reminder for our delegates that after the fireside chat, we will have closing remarks from our chief guest, Mr. Gary B. Bourne. Once again, we thank Mr. Lal and Akin Gump for conducting this interview.
Good morning, good afternoon, and good evening to colleagues wherever you are around the world. This is the SCL India virtual conference, and in particular, the fireside chat with Sir Rupert Jackson. Now, I'm delighted to welcome Sir Rupert to this fireside chat, albeit virtually. As many of us will know, Sir Rupert practiced as a barrister up until 1998, starting in 1973. He was, of course, High Court judge, led the Technology and Construction Court in England and Wales, and then was in the Court of Appeal until, 2018. Now Sir Rupert sits as an arbitrator, mediator, adjudicator, and occasionally sits in the Court of Appeal and the Privy Council. He is also a part-time judge in the Ashtana International Financial Centre Court. Sir Rupert, welcome to this virtual fireside chat. We are delighted that you are able to join us. So thank you very much indeed.
Thank you for inviting me, Hamish, to your fireside.
Thank you. And let me start, Sir Rupert, just by asking you, so what is keeping you busy at the moment?
I am working on a massive arbitration which will run for 8 weeks. The arbitration was to have been done overseas, but because of COVID, it will at least in part be done remotely.
Yes, and that was one of the questions that somebody had sent in to ask you, your own thoughts on virtual hearings. Of course, they may be unavoidable, but do you see virtual hearings as a necessary, as vital, given what's happening at the moment? But also, do you see virtual hearings requiring adaptations or longer periods? Do you see any issues with virtual hearings?
Well, first of all, the technical and technological experts have been saying for a long time that the legal profession needs to do more cases online in virtual courtrooms. And suddenly the COVID pandemic came and many of their prophecies have come true. And there has been a complete revolution in our approach to technology. It's very difficult actually to think yourself back 2 years. But I remember in April of last year, just after the pandemic arrived, I and two colleagues were about to start a quite complex 5-week commercial arbitration. And leading counsel on one side submitted that it would be quite impossible and improper to do such a case remotely. He pointed out that we were all in our rooms and family members and others could walk into the rooms and hear what was going on in the arbitration. There was no substitute for a proper in-person hearing in the arbitration room. Therefore, we must all pull up stumps and adjourn the case until the pandemic was over and the matter could be heard in the IDRC. Well, that application was opposed by the other side. We gave a lot of thought to it. We could see the difficulties of a virtual hearing because this was terra incognita for us. But anyway, we decided to go ahead and direct that there should be a virtual hearing with us all sitting in our studies at home and the witnesses being cross-examined from their homes or their offices or whatever around the world. And we discovered that that worked very well. And since then, like no doubt you and many others at this conference, I have done a large number of virtual arbitrations. I cannot deny that it works extremely well. It's a system which can be operated in the conditions of the COVID pandemic. And also, when the pandemic is over entirely, and that's not yet happened, although we're moving towards it, but when it's over entirely, there is now a decision to be made in every case. Are we going to do the hearing remotely, or are we going to do it in person? And I think there is something of a split in attitudes. Most arbitrators I know, and certainly I myself, much prefer in-person hearings. I like to be in the arbitration room. I like to have my colleague sitting next to me. I like to have the counsel sitting at their respective tables and the witnesses sitting at the witness table in the center or wherever in order to give his or her evidence. So I think it's fair to say that many arbitrators, like me, much prefer an in-person hearing. But I'm not sure that that's necessarily true for counsel, and especially for clients. I think clients appreciate the cost saving of a virtual hearing, and they appreciate the avoidance of need to travel. And also the benefit of a virtual hearing is that anyone in the client's office can tune in to watch what is going on. And there are some cases which would benefit from settlement for reasons I can elaborate upon. And if senior management on both sides tune in and watch what's going on for a couple of days or a couple of hours, they might pick up the phone to each other. Yes. So there are advantages for the clients in virtual hearings. There are disadvantages for arbitrators, but arbitrators are providing a service to clients, and so we've got to do whatever they want. And as for practitioners, well, you're probably in a better position than me to say, but I think practitioners' views are split. Some think that virtual hearings are the way forward, and others, like myself, prefer if they can have it an in-person hearing.
Yes, I think that's right. What I'm seeing myself is a lot of virtual hearings for procedural matters or applications, but there is a tendency, especially in construction, with more of the experienced arbitrators, to prefer, wherever possible, an in-person hearing or even a hybrid hearing. So at least some of the key evidence is heard in person. But it's moving all the time.
Yes, I think what you say about procedural hearings is plainly right. I think the days of getting onto a plane in order to go to Singapore for a half day or a 1-day case management conference are well and truly over. Procedural hearings, absent exceptional circumstances from now on, I think will always be remote.
Yes, no, absolutely, absolutely. Okay, now in preparation for this, Sir Rupert, I contacted some of the organisers of the SCL India conference, and I was inundated with a number of questions. I just couldn't put the 50 or 60 questions that I had received. So I've sort of narrowed it down to 7. This first question is a difficult question because it's quite complicated and you could talk at it at length. And the question is this: you have seen a great deal in your career, both as a judge and as counsel. But looking back at your career, what 2 or 3 cases would you say or highlight are truly seminal in the context of construction law?
That is quite a difficult question. Wembley Stadium generated a lot of litigation and occupied me for months on end because there were a series of different Wembley Stadium cases. There was Honeywell and Multiplex and the Football Association, Multiplex and Crown House, I think Multiplex and Mott MacDonald, and others. There were a number of cases. I can't remember them all now. One of those cases did give rise to the interesting question: what happens when a contractor has a good claim for extension of time but doesn't serve notice? Does the prevention principle prevent him getting an extension of time? Does the prevention principle protect him against liability for liquidated damages, or is the fact that he's not given notice something which disentitles him from an extension of time and exposes him to liquidated damages? And I had to deal with a number of conflicting authorities. I can't remember the name of the case now.
Yeah.
It was Multiplex and someone or other. And I dealt with that. That, I think, was quite an important case. I think at the very beginning of my time as judge in charge of the Technology and Construction Court, I had to decide when a dispute arose for the purposes of triggering an arbitration clause. I think Tarmac was on one side. I can't remember who was on the other side. It went to the Court of Appeal, but the Court of Appeal upheld my reasoning. So I think that decision is quite often cited. Do you know? Can you remember its name?
Is it AMEC?
AMAC, yes, it is.
Yes, and the Highways Authority.
Yes.
Yes.
I think that was quite an important case.
Yes.
I think quite a few of the cases I dealt with decided points of law one way or the other.
Yes, absolutely.
Well, those off the top of my head and without advance notice of the question, those are 2 cases which come to my mind.
No, thank you.
A fair number of cases about adjudication, dealing with all the adjudication issues when you can have serial adjudications and so on.
Sure. But yes, I agree. I think these 2 cases, I think it's Multiplex and Honeywell.
That's the one, yes. Multiplex and Honeywell dealt with the time bars point.
These are indeed seminal cases, and we see them cropping up in international jurisprudence, in international arbitration, as well as in domestic cases. So thank you for that. The next question, of course, you Sir Rupert, are not a full-time judge in the Court of Appeal, and you sit as an arbitrator. And the question that's come from an arbitrator in India is, do you see similarities between what you did in the court system and what you now do as an arbitrator? But also, do you have any key differences that you think?
Well, of course, the court process has changed a lot over time. Trials now in the courts proceed much more swiftly than they used to. And I am now comparing arbitration with first instance cases, which I did as a High Court judge up until 2008. Because after 2008, I was in the Court of Appeal and didn't do any first instance cases. And there may well be great differences between how first instance cases were done before 2008 and how they're done now. But making the comparison which I do, I find that arbitration hearings, the final trial in an arbitration, proceeds far more swiftly than the equivalent case would if tried in the High Court, certainly in the period when I was a High Court judge. But I was thinking of the Wembley Stadium litigation, the trial of Multiplex and Crown House. The main trial must have gone on for very many weeks. I strongly suspect that if that case were arbitrated, the hearing would be much shorter.
Ah, interesting. Okay.
I think one reason why arbitrations tend to move more swiftly than trials do, or at least than trials did in my day, is that arbitrators have time to pre-read. And if I have a heavy case with umpteen volumes of documents, whether on paper or electronic, to read, I can set my own timetable and I can say how many weeks I need for pre-reading. That is not a luxury which is available to judges at first instance in the courts. You have to do the case on the day. You will probably, save in an exceptional circumstance, you'll probably be reading up for it over the weekend beforehand. So there is more time available for preparation as an arbitrator. If you're a responsible arbitrator, I think it is grossly irresponsible to take on heavy cases which you do not have time to prepare for. And I believe that most arbitrators, and probably all arbitrators, do act responsibly and allow themselves enough preparation time before a big hearing. I mentioned the 8-week hearing I've got coming up straight after Christmas. Well, I'm at the moment spending many weeks pre-reading for that. And I wouldn't have this luxury if it were being tried in court.
Yes.
There are other differences actually between cases in court and arbitrations. One is that when a judge is under huge pressure and you've got a backlog of cases and others waiting in the wings, sometimes the judge can get a little bit testy with counsel or everyone else, a bit grumpy, if they're not sticking to the point and are wasting time. But as an arbitrator, I'm at the service of the parties. And if they agree to have a hearing of X weeks and I agree to that, I must sit there and listen patiently. I think arbitrators have to be politer to counsel.
Yes, yes. Yeah, no, I agree with that. Yeah, absolutely. And there is a little debate, especially where we have 3 arbitrators and party-nominated arbitrators. There's always a concern, especially with US clients, that the arbitrator that they have nominated should, at the very least, understand, advocate that party's case, whereas those of us in Europe don't share that view.
No.
But I definitely see tribunals be much more patient with the parties and the counsel teams, even when arguments are being advanced that don't move the dial.
That don't what?
That don't actually advance the case.
Yes.
They be abandoned for evidential or legal reasons. I do see tribunals very patiently go through everything, which is very different to court.
Yes. I mean, you may well be right that there are some arbitrators who feel a continuing sense of loyalty to the party which nominated them. But I think it's fair to say, certainly in this jurisdiction, that a party-nominated arbitrator, an arbitrator nominated by one party, does not feel any obligation to advance the case of that party or to press the case of that party. In all my experience, sitting with colleagues, is that we all, the 2 wingmen or wing ladies, wing people, forget which party has nominated,
Yes.
and concentrate on the case. And the chairman, of course, is agreed between the two party nominated arbitrators. I don't think that there's any continuing loyalty in that sense to the party that nominated you. The party has nominated you because they think you will do the case properly and fairly, and you will listen to the arguments of both sides. And that's what one does.
Yes, no, absolutely, absolutely. It's in nobody's interest to have a final award that might have any sort of difficulties at ratification or enforcement. So absolutely, absolutely. Now, so Rupert, just moving on, we have a number of expert witnesses watching this fireside chat, and there's always a debate in international arbitration about the use of witness evidence. And one of the questions that's come into me is, do you, Sir Rupert, have any thoughts about the use of expert evidence, and in particular, what, in your view, makes a good expert?
A good expert writes a clear and concise report where he does not support the views of the party which appointed him, or instructed him. He or she makes that perfectly clear. And the good expert writes in clear, user-friendly language that an arbitrator who is not an expert in that field can understand. I have seen some good expert reports where the expert candidate says, well, I can't support the party which has instructed me on this point or that point, but I do on point 3 or whatever the case may be. And one can then see that the expert is discharging his duties honestly and honorably, and don't suspect any bias on those matters where the expert supports the party which instructed him. So a good expert's got to be seen to be fair and deploying his expertise with the assistance of the tribunal rather than to enable his own client or her own client to win. Also, as I said, it's very important that the expert's language should be intelligible to the layman. I've had one expert in an arbitration earlier this year who wrote in highly technical language, which is extremely difficult to understand, without any sympathy for the tribunal.
Yes.
has to read the report.
And are you, Sir Rupert, a fan of what I would call visual demonstration exhibits provided by experts, sort of, whether they're videos or presentations?
It depends on the case. There are cases where a presentation is very helpful, and there are cases where a presentation does no more than reiterate what's in the expert report that the tribunal has already read. So I think it's a case of horses for courses there. Yeah.
And your views, Sir Rupert, on what we call expert witness conferencing or hot tubbing?
I think hot tubbing is a good thing. The background here is that it was first developed, I believe, in Australia. It wasn't, I don't know how long it's been used in arbitration, but certainly in the courts, it was first developed in Australia, and at that time it wasn't used at all in the courts here. In 2009, I was given the task of reviewing our costs rules and our civil procedure rules in order to consider ways of streamlining the litigation process and controlling costs. And in that exercise, I did a round-the-world trip at your expense in order to study the way a number of our jurisdictions operated, including Australia. And I was impressed by much that I saw in Australia, in particular the hot tubbing regime that was used in the courts. Judges spoke about its effectiveness, counsel did, and so interestingly enough did one or two clients I spoke to. So I recommended that we should we should pilot a regime of concurrent expert evidence, colloquially known as hot tubbing, and if it was successful, we should introduce it. I set up such a pilot at the specialist courts in Manchester in about 2010 or 2011, I believe, and the pilot was monitored by Professor Hazel Gain of UCL, who gave it a cautious thumbs up. And then it was introduced into the civil procedure rules in 2013 as an option available to the courts. So now sometimes courts do make orders for hot tubbing or concurrent expert evidence, and they've got a framework within the rules in which to do it. I understand from judges that they find it extremely effective. Curiously, I haven't had the occasion to do any hot tubbing in my own arbitrations. In all the cases I've been doing so far, the experts have given their evidence sequentially, but I'm very eager to try a hot tub when the opportunity arises.
Yes. No, I must say I do think it's very, very helpful, especially where experts appear in the first instance to have polarized opinions, but when they are seated together and debating it, it's much easier to see the points of agreement.
Mm.
So I think that much of hot topic, and I think it will catch on in international arbitration as we go into other jurisdictions.
Yes.
On a similar topic, we are having a debate at the moment about witness evidence and the usefulness of witness evidence, especially in the context of an arbitration where there is a very good documentary record. A lot of construction projects may have what we call databases, Akin and Foresight and so on, that record all the project correspondence. So we have strong documentary records. And the questioner has put the point, do you, Sir Rupert, in that situation, see significant value in testing witness evidence, long witness statements and cross-examinations, when the documentary record is pretty coherent and consistent?
Well, there are actually 2 points there. The purpose of oral evidence is not just to test what the witness says, it also has an explanatory function. Quite often, when you read the documents in a case, they don't make sense. What on earth is this talking about? Why was that email sent on the 5th of June when everything was apparently sorted out on the 1st of June? Or what is the gadget being discussed, or the bit of the building that they're talking about? Because quite often documents use shorthand, and witnesses have an explanatory function. I do know from my days at the bar, sometimes going through a bundle and not being able to make head or tail of some things, but I have a conference with the witness or with the clients, and they say, oh no, this letter was drafted but never in fact sent because we thought better of it. All sorts of things can be given in explanation which bring the documents to light and make them explicable. So my first point about witness evidence is that we do need witnesses to augment and explain the documents where otherwise they wouldn't make sense. And very often that explanatory evidence is not actually controversial at all, but it serves an essential function. Then we come to controversial evidence, oral evidence, about facts which are in dispute. And as you say, very often the documents will point strongly one way or the other, and there's not much the oral evidence can do about it. But nevertheless, my experience is that good cross-examination is an excellent way of testing evidence and bringing matters out which one would not infer from the documents. I mustn't breach confidences by citing examples from recent arbitrations, but I can think of a number of examples in recent arbitrations that I have done where cross-examination brought out from the witness far more than I would ever glean from looking at the documents. So I think that cross-examination is very valuable and oral evidence is very valuable. What we do need to do is to have witness statements pruned down so they actually cover matters on which the witness will give oral evidence and nothing else. And we don't have pages and pages summarizing documents.
Yeah, absolutely. That's very clear. No, thank you for that. And then, Sir Rupert, my final question, I guess, really comes from some of the undergraduates and postgraduates watching this and attending this virtual conference, they, Sir Rupert, would treasure your advice. They are about to enter the world of construction law. And one of the undergraduates has asked, what advice would Sir Rupert give to me?
Gosh. Well, the first advice I would give would be to get some excellent textbooks. If I start naming Keating and Julian Bailey and Duncan Wallace and so on, there are a whole range of Wilmot Smith. There are a whole range of excellent textbooks. You do need to get some and read them. That's my first piece of advice. You need to have a pretty solid understanding of the law before you delve into the minutiae of any particular case. My second piece of advice is that it really links in with what we were discussing about oral evidence a few minutes ago. In order to get on top of a construction case, an efficient way to proceed is to have a long conference with the key people and the clients. Don't think you can get all you need to know just by reading the bundle. Once you're sitting in your chambers or your office and you have the key people from the client sitting around you, you've got the bundle open and you've had a canter through it before, and you start talking to them about the construction project, the case comes to life. And you will learn far more in that half-day or one-day conference than you ever would from 2 days sitting bundle reading. So the importance of talking. I suppose now you could do that on a video link without having them in the same room, as long as you've all got the same documents open. So my first advice is learning the law. My second advice is the benefit of conferences. My third piece of advice is that ruthless preparation for a hearing is important. When I was at the bar doing difficult cases or difficult trials, I would work very long hours. Colleagues used to tease me because I used to keep a camp bed in chambers, so that in the middle of a difficult cross-examination, I could simply work for most of the night and just get a few hours sleep on the camp bed and then continue. Yeah. I've been teased about that for many years, ever since leaving the bar. And I'm not saying everyone should go off and do that. But the point I'm making is that when you're in a hearing, things are moving fast, new evidence has cropped up. You need to go back to the bundle to see how what the witness has said today fits in with the documents. Ruthless hard work is what the advocates on both sides need to do. And in my experience, do. I think the fourth point I would make is that construction law has an unjustified reputation for being a bit dull. A lot of people in other spheres of law think that if you practice in construction law, you're counting damp-proof courses or similar activities, and it's not really proper law. In fact, construction cases have huge practical interest because you're dealing with major construction projects around the world. And secondly, they generate a lot of major legal issues. If you look at the leading cases over the last half century on duty of care, contract, and so on, you'll find that a lot of them arise out of construction disputes.
Yes. Yeah. Absolutely.
So I would say that.
Yeah. I would certainly echo that, all of that. But your fourth point is very true. I mean, we very often see cases that intersect international construction arbitration and investor states, especially when we look at concession agreements or road projects or in overseas jurisdictions. And second, in the oil and gas sector, there's often a production sharing agreement or a joint operating agreement that creates what I might call pure commercial disputes, but they are all derivative to the construction dispute. But the construction dispute's never dull. I mean, And one thing I always find, to Rupert, is the clients and witnesses and even experts in construction cases tend to be very, very interested. They always have a lot going on,
Yes.
a lot of character and stories. So, your advice has been excellent. It's advice I've written down, and I will seek to follow all of it, even though I'm no longer an undergraduate. I think it's
Right.
excellent.
May I add a fifth point, please, Hamish?
Please? Yes.
Settling cases. Some cases need to be fought because of the issues at stake, the money at stake, and so on. But there is a raft of cases which cry out for settlement, where there are claims on both sides arising from a multiplicity of points. And although everybody says they're right on every single point, the reality is that nobody wins on every point in that sort of case. And very often in those sorts of cases, when each side has had its shout and has won on as many points as it can, and you net off the overall position, the final sum of money going one way or the other doesn't really justify all the effort and expense of the arbitration.
Mm-hmm.
There is greater scope for settlement in international arbitration, I think, than parties appreciate. Most construction cases in court do settle before trial. Arbitrations are less prone to settlement, and I do see arbitrations which really cry out for settlement. And very often bilateral negotiation will be the best way to achieve a settlement, but there are cases where you do need a mediator to crack them, and I've mediated some cases in that category. And achieving an amicable resolution where that is possible is just as important as running the whole way around the course and getting to the end and getting an award, which may or may not be what your clients want.
Yeah, no, absolutely. I agree with you. The difficulty I have with this concept of trying to get a resolution of some or all of the points in dispute is very often the other side just doesn't want that. They want to go all the way, and they would rather have the bad news codified in a final award rather than be seen to make a concession, especially when we look at international clients in certain cultures.
Yes.
There is a cultural impediment to resolution like that.
Well, I do understand that, and as arbitrators, if we're asked to decide the dispute, we will do so. I think, and I accept there are many cases which need to fight, but I accept that there are some cases which would benefit from settlement.
Yes.
And it may be that if management tune in, as I was saying earlier, and watch some of the proceedings on live stream, as is now possible and did not used to be possible, but it may be if they do that, they also will spot the desirability of an amicable resolution. If, for example, they watch a case management conference 3 months before the hearing begins, or 6 months before the hearing begins.
No, absolutely. I think that I took a note of that. I do see that as one of the major, but not very often discussed benefits of virtual hearings, that it does broaden the viewing platform for a number of people.
Yes.
Great. All right. Now, Sir Rupert, you have been very kind. You've been very patient. These questions hit you. There was no pre-preparation. I think you've done a fantastic job. I've enjoyed very much talking to you today. I hope you have enjoyed answering these questions. But
Yes.
On behalf of the Society of Construction Law India, and in particular the organising committee, can I thank you most warmly for your time, for your advice, and for sharing your thoughts on this fireside chat.
Well, thank you very much indeed. I have enjoyed chatting with you. As you say, I did not have any advance notice of the questions. That's probably best. It's been a great pleasure to have this chat, and I wish everyone participating in the SCL India conference every success in their deliberations. I'm sure it will be a great success. Thank you.
Thank you, Sir Rupert. Thank you.